Welcome everyone to the launch of our report, eBooks and Secure Digital Lending in European Libraries, Comparative Analysis under National and International Law. Um, so welcome. My name is Ben White. I'm one of the co-founders of Knowledge Rights 21. We are a Arcadia funded project working towards a better regulatory and legislative environment to support education, research, and the libraries that support those two fundamental pillars of the knowledge economy. eBooks is a major issue for Knowledge Rights 21 and for libraries, but of course, most importantly, the students, the researchers, the members of the public that use those libraries. So and this is, I think, this is the second report that we have funded on eBooks. So the first was a Spanish study by Raquel Calabada. This is our second study that's been published, and we're hoping before the summer a third study from the University of Glasgow Create Centre on eBooks, copyright and competition law will be published. So it gives me great pleasure to introduce the author, Dr. Konrad Gliściński from Jagiellonian University. He is the author, but also one of the prime researchers, and I will also thank our co-publishers, Centrum Cyfrowe and Future Law Lab, for all the work that they've done on this, and the co-researchers alongside Konrad, Eva Laskowska-Litak, Maria Drabczuk, and Katarzyna Strejharz for all their work. This is a phenomenal piece of work. I've put in the link in the chat, the link to the study. So taking a step back, the study focuses mainly on 2016 ruling from the European Court of Justice on whether the existing rental and lending directive requires amendment to support lending of ebooks by libraries. So what Konrad and the other researchers have done is they've looked at, I'm wanting to say 30, maybe more countries across Europe, and looked at national law and analyzed the ruling from the European Court of Justice to establish the extent to which lending under the current rental and lending directive is facilitated by national law. That's very high level summary of it. Taking one step back, the move from analog to digital has caused much disruption for universities, libraries, researchers, and ebooks is one very important example of how this shift to digital and therefore licensing has undermined the fundamentals of what libraries do. Those fundamentals are underpinned by copyright. So the function of a library, many libraries, of course, will preserve material. Copyright allows the preservation of analog material, non-licensed material, while the work is still in copyright. Copyright through the exhaustion doctrine and limitations and exceptions, as we see under the Rental and Lending Directive, support lending of books. And of course, collection development is being hampered by ebook licensing models, which allow publishers to refuse to license ebooks to libraries in the way that they cannot prevent a library from acquiring a paper book. We're obviously high prices is an issue, refusal to license, bundling of titles. So it's impossible for libraries to simply acquire a title that they want to acquire. They have to purchase a bundle, which of course at the end of the licensing period disappears in a puff of smoke in many instances. So across Europe, we are investing, I think, billions in electronic content, and yet at the end of the licensing period, in many instances, the shelves are empty. And I think last but certainly not least, because ebooks are licensed, and because they're protected using by they're protected by technical protection measures, we face the fact that ebooks will, in many instances, never enter the public domain because they're not governed by copyright. They're governed by contracts and licenses, which will, one assumes, in many instances, will not allow the item to enter the public domain. So for those of you who are aware of European policy around orphan works, we can use the same moniker and say that because ebooks will, in many instances, never enter the public domain, we're facing a black hole of the 21st century. And of course, the public domain is hugely important as a source of creativity, innovation, research. So many, many issues, which I'm sure Konrad won't touch on all of them. I'm sure he will touch on many of them. So with no further ado, it is my great pleasure to hand over to Konrad.
Hello, do you hear me? And can you see my slides?
Yes.
Okay, that's great. So without further ado, I want to start with my presentation, but I need to do one thing. Okay, and now we can move on. Okay, so hopefully yesterday we were able to publish our report, and this report contains or is put together in two separate files: the main report and the appendix to the main report. I will today concentrate on this main report and the findings of this comparative analysis, especially from the perspective of the European law. But also it is important to understand that in appendixes, we try to put together some kind of summary of law which we analyze. So if you are in a particular country, you can look at those you can look into our analysis of your local law, and then try to compare it with our general assessment. Of course, I don't have all those details in mind because it was a quite lengthy process, but still, I think it could be very helpful to navigate our work. As Ben mentioned, I am the principal investigator in this report. My work was highly supported by my wonderful contributor, as he mentioned, Ewa Laskowska-Litak. She is our professor at our university, Katarzyna Strycharz, and also Maria Drabczyk. I also want to thank to our excellent reviewers, especially to Professor Katarzyna Laskowska-Waśniowska and Professor Katarina Zganga, both of which important reviews helps us to make this report to be more legally correct and more persuasive when it comes to analysis which we provide. Last but not least, we conduct the survey with cooperation with national experts, and I also want to thank all of them, all of those people who respond to our questionnaire, who gave us some kind of general information or some quite specific information of their local, national legal system. Okay. But the main two questions to our survey, to our report, was like that. First of all, we wanted to understand if particular model of e-lending, which we called independent secured digital lending, is acceptable at the level of international law at the European law level, because this is a starting point for further inquiries. So this is the first question, and I will concentrate on this most extensively during this presentation. But also there was another question: if this model is acceptable from the perspective of European law, how international laws, how international individual countries are suited or are suitable to accommodate this particular model of e-lending based on their current legislation. And I will show you our summary results in this regard at the end. Okay. What is important, we also need to use some kind of terminology, because we need to know where we are and what this report is about. In general, you can imagine possibility of e-lending in general, not from the legal perspective, but in general, which could be based on those three different sets of situations. So first of all, you can have a situation in which you get an access to an ebook-based license mechanism. In our report, we try to understand what is a difference, what are advantages and disadvantages of relying on the license when it comes to providing books to libraries patrons. So this is one set of situation. Second sets of situations are based on this flexibility of copyright models. And here you can have this something which is called controlled digital lending. So the mechanism which was developed and which is suitable for United States. And I will briefly mention this in a second. Our independent secure digital lending, and also something which we can call the friction-free models. So those kind of models which are outside of the restriction which are provided by the controlled digital lending or independent secure digital lending, because those models, as I will try to present, they give possibility to e-lend books by the libraries, but of course they come with a lots of, they are associated with a lots of conditions which need to be fulfilled to provide this type of e-lending. Just briefly, I think it will be useful to make a short distinction between this United States controlled digital lending model and controlled digital lending and our secure digital lending, because both of those models have the same mechanism. They try to provide the same way of delivering the ebooks to the patrons. So first of all, the library need to possess a physical copy of a book. There is some kind of limitation, which is called one copy, one user, or loan to own ratio. And what's also important, there need to be a limited period to which this book is lended to the patrons of the libraries. But this is like a mechanism how it operates and how it works. But the legal basis for this mechanism is totally different, and that this difference in this legal base is absolutely crucial to understand how this our model can operate within the European Union perspective. First of all, controlled digital lending in its model presentation is based on somehow combination of the first sale doctrine, which is something similar to our exhaustion doctrine, or the exhaustion of right, and also by American fair use mechanism. On the other hand, our system is based on first of all, of the rental and lending directive, and the possibility which is provided by this directive to derogate some parts of the exclusive rights by member state countries, and also with the combination with the InfoSoc directive. So as you can see, this mechanism is based on exceptions and limitations, which are very specific for the European law union. And that's why it comes with additional layer of mechanisms, because in this pure controlled digital lending situation, you can find in those white papers that there is no mentions about any type of remuneration, because from their perspective, it was built on the assumption that the price of the sale of goods, that's why the first sale doctrine is important, somehow covers the lending elements. When it comes to European law, it is not the case, because we separate selling of books and selling the copyrights from the lending of the material. So there are separate types of rights. And our Article 6 of this lending and rental and lending directive tied a possibility to derogate from the exclusive right only when there is a provision of some kind of remuneration. Of course, country can provide a different mechanism of this remuneration. Country can also set a situation by which some types of entities are not obliged to pay this remuneration. That's true, but as a principle, there is a kind of remuneration within the system. And of course, why is it so important to have this distinction in mind is that maybe you heard or not few years ago, there was very important judgment from the United States courts, which says that there is a flaw in some type of controlled digital lending. But as you may understand, because our mechanism is based on totally different legal basis and have a totally different legal structure, this kind of judgment somehow cannot be translated to our situation whatsoever. So how we can understand this independent, secure digital lending? Here you can see some kind of a short summary. I will try to, during our discussion, explain most of those elements. But at the end, I want you to have in mind that when we talk about the secure digital lending, we are talking about the situation when the library possesses a physical book, copy this book or create an e-book or electronic version of that book, and then lending this book to its patrons. And of course, to look at this mechanism, first of all, you need to very briefly understand this mechanism through the lens of the international law. But the problem with the international copyright law is that we do not have any types of exclusive rights when it comes to lending. None of international convention like the Berne Convention or the WIPO Copyright Treaty do not provide anything about the lending rights. They only provide a mechanism or the exclusive rights when it comes to right of rental, so the commercial usage of works, and of course right to distribution or right to communicate to the public. Those elements are important because it gives you a general flavor where we can situate legally digital e-lending done by the libraries. What is really important to know that when it comes to lending, because there is no such a regulation at international law level, we need to distinguish between those two types of situation. First of all, there is traditional lending based on the material books or other material carriage of the works. And when it comes to this type of lending from the international perspective, we will try to assess if this kind of activity is allowed through the lens of the distribution right and associated with this distribution right construction of exhaustion of rights. When it comes to, on the other hand, to this immaterial element, we will need to discuss this through the lens of the communication to the public right, which unfortunately does not have this exhaustion right mechanism. Okay, but at the end, we still can think that this is possible to provide this kind of immaterial e-lending as long as it will pass three-step test. And we'll go back to this later on. Because when it comes to qualification of those e-lendings from the perspective of the EU law, we need to distinguish, as was mentioned before, two very important rules. Because before this VOB ruling from 2016, there was a general consensus in academia, I would say, or in many people, that European law generally does not allow any type of e-lending. This was a understanding that if you want to e-lend something based on European law, you need to do it based on a licenses mechanism. And of course, if you don't recall that, there is a wonderful article by Professor Desilliers, which shows why this mechanism is not right and why there is drawbacks in relying only on the licensing, but still somehow upholding that this is the legal situation when it comes to European law. Why it was like that? Because from the EU perspective, there was an important discussion about the idea of a copy. There was this kind of understanding that the copy need to be understood as a material copy of a book. So when it comes to lending, we can rely on those exceptions, this Article 6. But when it comes to e-lending, because there is this electronic element of the story, so we should rely on the right to make available to the public, and because there was no applicable exception or limitation to that, it means that at the end it was not possible to provide this kind of mechanism. But this understanding of the EU law was totally reshaped by the European Court of Justice. The European Court of Justice in this VOB ruling told that this understanding is not suitable. It's based on the false assumption on a mechanism built in the lending when it comes to European law. At the end, European Court of Justice says that this is possible to base e-lending on Article 6. So there is no more problem with a copy as a physical thing, because this copy can also be understood as a copy of electronic mechanism. And in this VOB case, European Court of Justice create a set of requirements which need to be fulfilled if we want to provide the e-lending to the public. But from our perspective, I think there are two the most important ones, because I mentioned you that there is this mechanism of the one copy, one user model. So if you want to provide this type of e-lending, you need to base it on one copy, one model user, which means that if you are lending to one of your patrons particular book, in the same time, you can do it only to a one patron if you have only one physical copy. If you have two physical copies, you can serve two patrons at the same time. But of course, at the same time, you cannot simultaneously lend this physical copies of those books. So you need to choose how you want to lend this thing. But the VOB scenario open two important questions and does not solve two important questions. So first of all, from this perspective of VOB scenario, lending need to be based, of course, on a digital copy of a book. And the question is from where this digital copy of a book library can have it. Otherwise, because from the VOB scenario, and I think it is a kind of important part of the European copyright law, which is stressed that all those exceptions and derogation whatsoever are based on this mechanism of the lawful source for this, for everything which you need to use, which you want to use based on exceptions and limitations. And that's why the VOB ruling opened two one important issue and one important practical problem. Where does the library can get access to digital copy of a book from the legal source? And I think this is the most important question which was perceived since 2016 in this way, that at the end, in practical terms, none of those libraries wanted to engage in e-lending. Why is it so? Because, of course, one important source of those digital copy of a book from a legal source is, of course, ebooks from the publisher. Of course, if you will get an ebook from the publisher, this is a legal copy, and technically speaking, it could be used when you want to provide the e-lending service. But there is a problem with this approach. So first of all, VOB ruling does not give us any direct basis to say, okay, I have my book from the publisher, and of course I enter into a license agreement with the publisher, but in many situations, or in most situations, those license agreement does not allow us to e-lend those books. This is a contractual obligation which says that you are not allowed to do that. And of course, VOB does not give us a question if library is possible to overcome those kind of contractual restriction. And on the other hand, does not provide us with any tools whatsoever what to do with technical protection measures, okay? Because in many cases, in most case scenario, I would say, those ebooks which are provided commercially by the publishers, of course, they are protected somehow. And in European law, in our in InfoSoc directive, we have a mechanism by which you can overcome or circumvent technological protection measures, but you cannot do it by yourself. Different countries provide a different mechanism how you can do it, and at the end, it may not be so practical. But still, VOB does not tell anything about that. So technically speaking, if you have a book from the publisher, ebook from the publisher, and this ebook does not have any restriction, contractual restriction about lending those, e-lending those books, and does not provide any types of technological protection measure, then basing on the VOB, of course, you can use it and e-lend it as normal books. A second problem, practical with this approach, so this license version, is that publisher, as was mentioned by Ben before, have a lot of problems with going into a licensing agreement with the libraries. And there are two important strategies when it comes to this element, which we just refer. I think that there are more recent publication on this topic, so you can follow that. But at the end, in general, it is observed those higher prices for selling the ebooks to libraries compared to other commercial prices of this particular book. And on the other hand, in many case scenarios, publishers or more often aggregators are offered the packages of books rather than a selected book by the libraries, which is very important, and I will come to back later on, which means that, and all of that causes that the library has no full autonomy about how they want to create their collections, what they want to deliver to their patrons, and so on and so forth. So that's why we call this version of the e-lending based on VOB dependent SDL, because it is possible only when publisher allow us to do it, or by doing it directly, by allowing this in the license, or just not to putting any kind of restriction in this area. And this is the first part of the story. And I think that this is the most practical understanding why none of those, since 2016, so it is more, it's 9 years ago, there was no massive e-lending process done by the libraries in European Union. On the other hand, from our perspective, and this is the main, I would say, innovative part of our report, was to understand, okay, so maybe we can also conduct the e-lending based on digitalization of a paper book by the libraries. Why? Because, of course, libraries have the paper books. Paper books are easily accessible to libraries. They can just buy them on the market or in the secondary market. Both situations are possible. So it is easy for the libraries to get the paper version of the book. And of course, we need to figure it out if there are any legal basis for that. So if there is any legal basis to create a digital version of a book, digitalized copy of a book, for the purpose of lending those things. And of course, from our perspective, a great source of inspiration was in other European Court of Justice judgment, which was called Darmstadt case, which was about totally different story. Okay, in the Darmstadt story, library wanted to display or to make available books to their patrons via, as you may know, this very ancient technology, which is called terminals. Okay, in Europe, in InfoSoc directive, there is a special provision which says that you are, as a library, you are allowed to display electronically books on these specially prepared terminals. But the main problem in the case was exactly the same as in our story, because, okay, you have this exception which allows you to display books on this on those terminals, but to do that, you need to somehow digitalize that book. Okay, you cannot display paper book via electronic means, so you need to digitalize books for the purpose of making usage of those electronic dedicated terminals. And in this case, European Court of Justice says exactly like that. Okay, of course we have those terminals exceptions, but to make it any kind working, okay, you need to have a right to digitalize books. And European Court of Justice says that, of course, there is this kind of exception in InfoSoc directive, which allows you to digitalize books if you are a library. And from the perspective of the European Court of Justice, we can combine those two situations together and make this a type of usage, possible. And that's why, from our perspective, we try to figure it out that the legal basis for the digitalization of these paper books, we need to follow those two logics. So from one perspective, the VOB ruling, which requires us to have a digital copy of a book from the legal source, and the Darmstadt case, which says, yes, there is a legal way to digitalize books based on European law, and you can combine those two things, because from time to time, some people argue that you cannot combine somehow exceptions and limitations, or they need to be tailored specifically for something. That's, I think, it's not true. And the European Court of Justice, I think, said exactly that. Why is it so important from our perspective? Because if we are understanding this e-lending based on this two judgments of European Court of Justice, we can serve, or we can help to provide the autonomy to libraries, because in this scenario, libraries are deciding by themselves which types of books they want to digitalize and which types of books they want to provide to their patrons. And nobody is able to restrict that, because they can buy those books on the market or primary market from the right holders, or from on the secondary market. And that's why we call this mechanism as independent secure digital lending. Once again, both situations are possible from the VOB perspective, but this one, I think, is possible without any restrictions from the right holders. And to be honest, this idea to combine VOB judgment with Darmstadt mechanism is not my own way of thinking. The source for inspiration, once again, is in opinion of Advocate General Maciej Szpunar, who was preparing this VOB opinion, who prepared opinion to the VOB case. And in his opinion, he exactly says that it is possible, that the whole point of that is to use this analogy from the Darmstadt case and to use this Article 5.c, which allows library to create digital copies of a book for the purpose of e-lending of those books. And from our perspective, this statement makes perfectly sense. Of course, in VOB judgment, court does not put this so blindly, but I think, and this is the whole point of our report, we try to show why this way of understanding current legal situation in European law is possible. So we've tried to provide, and this is the main part of our report, justification that this way of looking for the legal basis for the e-lending in this secure digital lending model can be found in European law. Of course, we also look quite thoroughly through the three-step test. We've tried to combine the three-step test analysis, which was invoked in the Darmstadt case scenario. We invoked the same which was used in the VOB scenario. We've tried to show why, when you put all those restrictions in place, so those one user, one copy ratio, if you put this kind of temporary of lending and so on and so forth, then you can find those legal grounds from the perspective of the European law. And this is half part of the story. The second half part of our study was devoted to try to analyze, okay, maybe there is a possibility in European law to do this kind of things, but maybe, but how this possibility is used by member state countries. And of course, to do this kind of comparative analysis is very difficult. Different country has a different attitude to everything. Of course, we have something like harmonization of the copyright, but in practical terms, we can just say that this is harmonization when it comes to exclusive rights, and also not all part of exclusive rights. But when it comes to exceptions and limitations, country has a lot of possibility to do different things differently. What is the most important? European law does not by itself require that the library need to, that country will, for example, provide the library with the exception for digitalization of the book. They not made the country obliged to provide this derogation from Article 6 of the Rental and Lending Directive, to which we will go back in one moment. So there is a lot of possibilities which country could do. And that's why it is very hard to compare those countries and to say anything about those legal situations without going to a very detailed analysis, which was, of course, outside of the scope of our possibility. But we want to judge those countries' regulation through the lens of those three elements, which we say, which we identify as a crucial for the e-lending book based on this independent secure digital lending model. So first of all, we were looking if there are in a countries some kind of regulations, provisions, which gives the libraries right to digitalize books. Okay, so we were looking if there in particular country, among the exceptions and limitations, there are some exceptions and limitations which will allow us to say, okay, maybe this is good enough for providing this eLending mechanism. Of course, we selected 3 possible scenarios. So first of all, there is direct right to digitalize books, and this was very a rare situation, but there are countries which allow for digitalization of a book. Then we look on those situations, those countries where they give the libraries a broad right to make a reproduction, okay? So they give the library the right to reproduce books, and they not say, oh, this kind of reproduction can be done only, by, photocopying mechanism or things like that. This is the right, the broad right for the reproduction. Or maybe there are some kind of possibility to create this kind of ancillary right based on this understanding from the Darmstadt case scenario. On the other hand, we also need to look for the second condition, so the library right to lend books. And of course, here we can have 2 important situations. First of all, direct right to lend books. There are countries which provide libraries the right to lend books. So we were looking at if there are provisions specific about the lending of books, but also we take into consideration the second possibility, so the broad concept of a lending. Because if European Court of Justice says like that, in our directive we use the word lending, and this word lending means lending material books, but also lending e-books. So we can use the same story when we assess legal situation in national law. And of course, this way of thinking is also based on something which is named autonomy concept of European law, which means that if European law provides some kind of concept, and the lending is a concept provided by the European law, and then European Court of Justice create binding interpretation of this law, which has happened in the VOB case. Now we understand that lending in European perspective is lending physical and lending e-books. It means that the same story should be translated into national law. And of course, there could be some kind of problem with that, because some countries will tell that the lending from their perspective is built only on the physical books, but maybe they don't put this so bluntly in the text. Maybe they are using different way to drive why they think that lending is based on only physical books, like in Germany, but still you can overcome those 2 things, and we will show you how we did it in a moment. And of course, at the end of the story, this element of the public lending, right? Because as I mentioned you before, lending in general in European Union law is based on the public lending, right? If there is not this element, of course, this is a problem, but this is a general problem. If the country does not provide this mechanism correctly, it means that this is problematic from the EU Union law perspective. In our report, you can find very detailed analysis of all those conditions and the variants which we identify. I will not go through details here, but in general, we make sure that we assess each of the legal provisions as we saw them on paper, as we understand them on paper, which was provided us by the expert or by our other source of information. Everything is detailed put in our report, and we make this charter which we go through each of those exceptions we assess each of those conditions when it comes to right to digitalize books, right to eLend books based on the legal text, and of course the third condition about this public lending right regulation, which was very difficult in many case scenario, because in different countries those regulations are put in totally different places, and it's very hard to understand how how they operate in practical terms. And based on that, we create this kind of comparative analysis, and we divide these countries in 4 categories of countries. The first group of country would be a group which encompass a country which have all those things in their regulations. So the right to digitalize books, right to e-lend books, and public lending right for those activities. And unfortunately, during our process, we didn't find any kind of country which have this kind of direct regulation of this situation. Then we have three important groups of countries, which first is group we understood as a possibility of interpreting the applicable national law in order to implement e-lending rights, because if in national law we assess there is no further restriction. So for example, the library have a right to reproduce a book, and there is nothing mentioned about the aim of this digitalization. Like for example, the library have the right to digitalize book only for preservation. It means that the library have a very broad right to digitalize. So we will put this in the second group. And then in a third group, we find countries where there were a problem, some kind of a problem within the text of the statute, which could provide some kind of obstacle. Like, for example, the library have a right to digitalize books, but only for preservation purposes. And then we open a question: if the library have only right to digitalize books for the preservation purpose, can he use the same legal basis to digitalize for e-lending? And in the third group, we have identified a lot of other additional layers of problems, which makes it even more harder to assess if a particular country allows digitalization for e-lending. Here you can see the map of the countries and the group of those countries. I will not go for this detailed analysis of them, and of course you will find in our appendix our assessment why we put those countries in particular group. I just want to give you just those general conclusions, which could be treated as a mechanism as a base for our discussion. So first of all, because none of those countries provides totally direct and without any problematic elements legal basis for digitalization, so none of those countries is in the first group of the country, it means that you can only create legal basis for this e-lending only if you implement some kind of interpretation mechanism. Okay, at the end, because there is no direct exception which says the library is allowed to digitalize books and e-lend it for its patrons, it means that at the end you need to interpret the legal provisions. And of course those legal provisions were created in different times. They were created with different intentions. They were created also in different legal construction in mind, especially like, for example, in Germany, because for example, in Germany, they think that they are, from their doctrine, they are stressing that the lending is part of the distribution right. So from technical point of view, cannot be understood as whatsoever as allowing for e-lending, because it is only for digital. But this is a doctrinal statement, of course. This is nothing in law which is put this like that, but this is a doctrinal understanding of the mechanism. And that's why when it comes to looking at those national law, you always need to look through the lens of the interpretation. And we try to provide somehow of the legal basis for the interpretation of those legal national provisions based on a fundamental rights perspective. Why is it so important? As you know, European Court of Justice since 2010 and later on start to stress that fundamental rights of the users of the works need to be secured need to be secured or directly in exceptions and limitations which are provided by the country, or through the interpretation. So European Court of Justice said that you cannot interpret your law in a way that you will omit or you will ignore fundamental rights of the rights holder of the users. Of course, there are rights of the right holder that need to be interpreted on one side, but on the other hand, you cannot interpret your national law, which will be in contrary to fundamental rights of the users. And we try to show a lot of evidence why this very limited mechanism, which is called independent secure digital lending, is very limited. It's first of all is limited only to one copy, one user ratio. Second of all is limited to the period of time, so you cannot lend it for forever. And third of all, you need to create those secure situation, like some kind of right management, which will cause that the lended book after some period of time will not be more available to the patrons. And when we are talking about this very limited mechanism of provide, and of course the library need to purchase the books in the first place, so you need to have this legal copy of a book, then need to digitalize in on the way which is provided by the law. So we was looking on those human rights of the patrons, and we try to explain why it is so important to have in national law possibility for libraries to provide such a service to this to the users. And I just want to stress two elements which from my perspective are highly important. First of all, the freedom of information, or freedom of expression, or freedom to education, or right to research. I put this in a very broad concept. Now I know this is very complex rights and there are different legal bases for them, but this is very important to understand that in nowadays to secure the access for the information, not only by to give access to physical books, is important from the perspective of research, from the perspective of able to participate in a culture. So it is impossible to say that I will interpret those regulations, for example, which says that the library have a right to digitalize books only for purpose for preservation, in a way in which it will block possibility to e-lend those books for the users. So we need to somehow find a way to interpret the legal provision in accordance to fulfill those fundamental rights. And the second and this is very interesting case scenario, because in the study which was done by Professor Halabander in Spain, it was exactly that case, because in the Spain copyright law, Professor Halabander says, of course, we can make this control digital lending, as she said, but they can e-lend those books, and they can make copies of their physical books, even though in our copyright, the library has a right only to create copies for the preservation purpose. But she is stressing, and of course there is a very elaborate analysis why from her perspective is possible to overcome this purpose, digitalization purpose, to facilitate the e-lending of the books, because of the fundamental rights. So we cannot ignore those fundamental rights perspective when we interpret our legal regulations, copyright regulations. And the second of all, which I think is also very important, for country to provide a mechanism based on independent, securely digital lending, is about the privacy. Now we need to go back to those models based on the license. When the library provides an access to a book by the license model, it means, and this is nothing wrong with that, but it means in practical terms that there we have at least three entities in this store. We have a user or the patron, we have a library, and also we have a provider of a service, like for example, aggregator or database on the publisher, which at the end gets some kinds of information about who is using what for what purposes. Of course, it is not problem with personal data. Of course, the personal data is also one layer of that, but also when you read books, when you acquire knowledge from the books, other data are collected, and especially from the perspective of freedom of research, in lots of situations, researchers need to be secure also from this information, that what they are reading, why they are reading that, how they are reading particular things, what they are highlighting in those documents, and so on and so forth. And that's why, of course, if a researcher is comfortable with sharing those data, not only the personal data, but also other types of data with the publisher, there's no problem for him to enter into this license model. But to create these safeguards where only the patrons and the libraries are engaged in a situation in which those data flows, we need to create this kind of second possibility, and this independent secure digital lending, which allows the direct relationship between the library and its patron, is really important from that perspective, because in this situation only the library knows what somebody is doing, and none other additional parties are involved, which is this typical situation when you go to the library. There is no, any types of, publisher eye, which was looking what you are reading, what type of book, who is reading, and so on and so forth. So there is this kind of secure private relationship between library and the patrons. Okay, so this was the general conclusions, and of course we end our report with the sets of the recommendations. I will not go through details here, but in general, we think that from practical point of view, if we want to have this broad e-lending possibility, we need to introduce this on the level of the European law. Because we know that this is the best way to achieve those goals. If we don't have this kind of straightforward exception, then everything is about the interpretation. And when we start to talk about the interpretation, there is a problem of risk, or maybe the misinterpretation, and so on and so forth. Second of all, as I mentioned you before, from my perspective, from our perspective, there is a possibility to introduce those exceptions directly to national law. So if European Union will not go in this direction, I think national law can do it by themselves. So adjust their legal system to accommodate possibilities for this e-lending in a very as I told you, very specific and very ineffective way, because I'm totally sure that independent secure digital lending is very ineffective. Okay, it's only one user, one copy ratio. This is very problematic, but still, this is legal from the European law perspective, so country can do that. And the third layer of recommendation, and we want to work on that with our Polish libraries, I hope sooner than later, is to create a national guidelines how this mechanism could be provided in your national law. As I told you, we in our report provide some kind of schematic mechanism of how we understood law in particular country, and how we can adjust this law to accommodate this SDL model. But of course, different country can have a different interpretation, different attitude when it comes to risk, different perspective of how it is possible or not possible. So I think, and what we were thinking of, is to create this kind of model guidelines for the Polish libraries, which will, we will discuss this with their directors, we will discuss this with their legal team, and based on our report, we want to provide a very detailed guidelines, what you need to do, how you need to do, what are the boundaries, what technical elements you need to take in place, and so on and so forth. So we are thinking about that because we think that it's possible to go to this direction, and this is the best way in practical terms to do it, because we don't believe that any library just by themselves will be so brave without having this further consideration to do it by themselves and see what happens. So from our perspective, would be much more suitable to create such a national guidelines, based on your national literature, based on your national doctrine, based on your national law interpretation. So that's all from my perspective. Thank you very much for your attention. And of course, if you have any questions, I will try to answer them, but we will see how it goes.
Thank you very much, Konrad, for a very clear and concise summary of what is a phenomenal study covering 22 countries in total. I suppose I just wanted to sort of pick out a few points. So as is very clear from Konrad's presentation, this study focuses on this 2016 ruling from the European Court of Justice. This is not to mean that there may not be other limitations and exceptions and derogations in national law that allow what Konrad has presented, sort of the lending of eBooks. So in terms of European law, there are certainly in some of the countries limitations and exceptions fall under 5.3a of the Copyright Directive, which are exceptions, illustration for teaching and for scientific research. So the study did not, just because of its breadth and depth, did not go into detail on that point, but this is not to mean that there are not exceptions already in your copyright law that may be usable for eLending. So in Ireland and the UK, see certain limitations and exceptions which could be used, I think, for eLending in universities, for example. So yeah. So this is sort of part of a broader picture. I put in the chat earlier on, I just wanted to bring your attention to a Knowledge Rights 21 ebook position paper and also an ebook pledge. And the idea of the ebook pledge is for librarians negotiating with ebook publishers that you can discuss the ebook pledge and the provisions that it puts forward, which are essentially aimed at creating the same rights and usage that libraries have regarding paper books via license negotiation. So the ebook pledge is there as well. I wanted to, I think, underline a point, and Konrad, please jump in and add to this. You made it very, very clear that although the study divides the 22 countries into 3 different categories, those categories are essentially sort of perhaps distance from the black letter of the ruling of the European Court of Justice, which is a binding ruling. And you made it very clear that essentially that those 3 categories require different levels of interpretation in order to allow eLending. As Konrad made very clear there with Spain, the black letter of the law might say you can only do preservation you can only do preservation as a library, but actually in the light of this binding interpretation, in the light of the European Court of Justice, underlining on numerous occasions that exclusive rights should not be to the detriment of fundamental rights.
I only want to add one more thing because I agree with this totally. Exception with one country, which is I need to focus. I always forget which one is that, because only in one country in Europe, yes, it's Slovakia. In Slovakia, they do not provide any derogation from the copyright when it comes to Article 6. They said that all those eLending is based on the contracts with the CMOs. So because of that, this is the only country, I would say, which will fall out from the scope of possibility of making that, because they just do not use Article 6. And as far as they don't implement Article 6, I think it is impossible for them to do it. But other countries, as you mentioned before, is exactly about the layer of interpretation and putting the weight of this fundamental rights discussion. Because what I think was, what is a prevailing understanding of the copyright is like that. There is a rise of the right holders. There is a three-step test which forbids you to do anything. And if something is not totally clearly put into the law, then you cannot do it. This is a perception which is no longer possible through the lens of the European Court of Justice. European Court of Justice said exactly the opposite. You need to interpret your national law in accordance to accommodate those fundamental rights of the users.
I just wanted to read out one comment from Anna Ordas saying, Konrad, the information was very well structured and clearly explained, especially considering how complex the topic is. Many thanks. So absolutely, it was exceptionally clear in regards to a very kind of complex topic. So if I may ask just one question as a former licensing manager at the British Library, in the study goes into this, but what's your view on your interpretation and contract? So you have a contract with a publisher for an ebook, for example, and it doesn't, it doesn't allow this. What's your view on how contract law and the European Court of Justice and this interpretation should
Okay, so I have I have a two different opinion on this topic, and they are quite contradictory. Okay, so first of all, I think that I will start from a different angle. A few months ago, Professor Geiger and you, they provide a very interesting study which shows that this is possible to overcome some kind of contractual restriction when it comes to copyright, and that they need to be that the right holders need to provide access to particular things, and they create situation in which it's possible. So I think this is the best way to start this discussion, because Professor Geiger is one of the leading copyright lawyer in European law when it comes to those topics. So I will rely on what he said. And this is how I would want to answer on Respond. But to be totally honest, when it comes to VOB, the VOB ruling is very weak when it comes to other stuff than understanding the concept of eLending, first of all. Second of all, when it comes to contract law, European law is problematic because we have not so much harmonization when it comes to contracts and how they operate in general. In European law, we have very specific contracts with the consumer. We have very specific contracts and protection against unfair consumer clauses and so on and so forth. But we don't have any European concept of a contract and how it operates. Third of all, we need to also know that in the newest directive, this copyright in a single digital single market directive, there are provisions against a contractual override. Okay, there are specific provisions which protects contractual overrides of particular exceptions. Unfortunately, in this directive, European legislators do not go further and do not state general rule that, okay, this is for those exceptions, but also it should cover other exceptions. So this is this kind of a problem. But of course, the problem with overcoming contractual agreements which are in contrast, or which are make usage of exception and limitation impossible is very long discussion. It started with a very good, very famous book for Professor Lee Gibbon about the contract and exceptions and limitations. And in different countries, you will find a different solutions. I can only end this part from the perspective of the Polish law, because in Polish law, you will not find any provision in our copyright which states that, okay, you can overcome what is written in the contract if it is contrary to exceptions and limitations. You will not find this kind of provision. And during our implementation of Digital Single Market Directive, our ministry, based on what is, I think, the common perspective of Polish doctrine, says like that, okay, of course we don't have this in our law because it is obvious. It is obvious that you cannot overcome exceptions and limitations by contractual stipulations. And that's why we are not introducing those things which are required by the copyright on the Digital Single Market Directive in our law, because we had this in our law since the beginning, because our construction of exceptions and limitations, which are fundamental and so on and so forth, of course you cannot do that. And this is a Polish perspective. From other perspective, because we now also run a different comparative study, we know that different countries have a different attitude to those, and there are countries in which they go Polish way, I would say, but this understanding that exceptions and limitations are fundamental and cannot be overcome by contract, and that's all. There are countries which stipulate this directly, so they put this kind of provision in the law that all those exceptions and limitations cannot be overcome. But of course, unfortunately, there are also those countries which are more vague in this territory, and they say, okay, this is a contract, especially the countries which believes in a total freedom of contracts. And they say, okay, we have freedom of contracts. Of course, there is exception limitation, but if you go into this kind of agreement, your hands are tied. So it really depends on the countries, and because there is no universal mechanism, it's very hard to say anything more than that.
Thank you. I guess I would just add a few more points to that. So we do have a number of countries, UK, Ireland, Belgium, Portugal, which explicitly do not allow exceptions and limitations to be overridden by contract law. As Konrad said, there are European countries, and certainly taking the line of argument from this study, if contracts override fundamental rights like the right of education, privacy, science, freedom of expression, then it would be very it would be deeply unsatisfactory if those fundamentals could be removed by contract law. And actually, if you read the ruling, the opinion and the final ruling in VOB doesn't really make any sense if suddenly you can say, oh, well, contract is going to prevent all this. And I suppose on the freedom of contract point, I would, and KR21 certainly argues very strongly that there is not freedom of contract between libraries who must purchase books in order to be a library and a party who has exclusive monopoly rights. So hence one of our positions is that we should expand unfair contract law to protect public institutions like libraries as well. So that's enough of me. I will now move to the questions. So first question, Konrad, from Anders Söderberg. When doing digitization ISDL, is it allowed to make derivations of the digitized copy, i.e. free files for accessibility?
Okay. This is another very interesting topic. We didn't go further in this direction, but from our perspective, I have a different attitude to that, in a sense that from my perspective, if the library is allowed to create a digital copy, from my perspective, it also means that it is allowed to make a digital copy which will be accessible to other people, which means that they will need to adjust to those disabilities. I'm saying in a very general manner, because I heard lots of rumors and a lot of discussions about that, because from my perspective, it is something which was put upside down. Okay, we create this Marrakesh Treaty, which allows, very once again, specific and very tight possibility to help people with disabilities. And we are looking through everything through that lens. And I think it's not the right perspective to do. This is additional instrument. It is, okay, this is my attitude. Additional instrument which are provided into exceptions and limitations should not eliminate other exceptions and limitations which could be more broad. So, for example, in Poland, before introduction of TDM exception, we have a very broad exception for research, okay? So introduction of this TDM, from my perspective, does not derogate anything from the previous exception. It gives additional layers or additional route or additional mechanism, and not derogate what was previously done or previously understood in the law. So I think the same story is here. If the library has a possibility to digitalize books, I think that this right should also, but it depends how the right is created, of course, but this right should also encompass the possibility to create this things for people with disabilities. But once again, this is something which we didn't explore in detail, because different countries, in each country there was additional, when it comes to this implementation of Marrakesh Treaty, all those mechanisms are very lengthy and a very detail-oriented mechanism, which, from my perspective, make things more hard to do than easier to do in some countries. So I think that this need to go to further analysis. And this national guidelines mechanism, which we provide, which we want to provide, of course, should take this element into account as well.
Thank you. So we will, I'm sure we will make the slides available to people. Certainly, we're recording this and it will go on the Knowledge Rights
of course
stream. So another question from Elizabeth Chantavaridou. I'm sure I didn't pronounce that correctly. What is a dedicated terminal? If a library provides a digitized copy of a book for members of the academic community by checking their IP address, is this legal?
Once again, this dedicated terminal, I don't want to go to detail, because this, as I told you, is an ancient technology. This is something which was created in 2001, so it's a very old thing. But library, at the end, if you have a physical library and you put the computer there, and the people can go there and check things on those computers, these terminals, this usually it is understood in those terminals. So it is very very physical thing, which is connected with the physical space of the library. This is the common understanding of those things. What you are trying to say is this additional mechanism which makes more dynamic interpretation of those terminals. But once again, we didn't go to this direction, because from our perspective, we don't need to care about this terminals as a mechanism to provide what we want to do. Of course, this possibility maybe is open, but we didn't explore it. From our perspective, if you are making this SDL mechanism, so when you are allowing to download a book which disappear, or you create this secure mechanism by which the people are just viewing the book, at the end both things pass the test because it was exactly mentioned by the VOB case. In VOB case, court says that you can provide those ebooks both two ways, mimetic and quasi-mimetic, which means that you can allow people to download those ebooks with this kind of timer which make the ebook disappear after particular period of time, or you can provide them with access to remote access to the things, and both of those things can be done without any discussion about those terminals. So this is something totally different. We only use this terminal analogy just at the first part to justify the right to digitalization, because I think it was very important to stress that European Court of Justice says exactly that. For if there is one exception, but this one exception cannot work without another exception, you can combine them and you can drive the right from one to help another. That's all what we wanted to say here.
Thank you. So another question from Daniel Coursera. If in the future publishers provide their entire catalogues in ebook format and allow libraries to individually select titles, would that be a way to block the advancement of ISDL, or at the very least to limit ISDL to out-of-print books?
I would say differently. Of course, this element consists two layer of discussion. First layer of discussion is this argument from the three-step test, because what I understand from your question is somewhere there, if there will be this kind of market or this possibility, then SDL should not step in this place. And maybe this correct. Nowadays you can't see that, so it's like a fairy tale. But I think we need to address additional elements to that. It's not only if they provide this thing in the same in a way which you describe. They need to provide it in a way which will help to protect all those fundamental rights, encompassing the privacy law. Because now we can observe that many publishers are trying to create their new business models, which are based not on selling the books or selling the access to the book or article, but selling the information about how things are used, how meta-analysis and things, and so on and so forth. And of course, to do that, they need to get information from the users, how they are using the works, and so on and so forth. So if in imaginary situation, publisher will give this kind of service, which will, tickle all of those human rights concern, then maybe a problem from the three-step test. But I'm not so sure if it's possible, because at the end, which means that they will need to allow for the eLending of their ebooks without any restriction and without any possibility to monitor the users, because this is the key point of what I think is very important and becoming even more important nowadays.
I suppose I would also add on something which I mentioned at the beginning, which is that we should not take our eyes off the long game. Publishers can make the books available, but under the existing system where these books are regulated by contract law and technical protection measures, we face a situation where ebooks will never enter the public domain. So, so what Daniel puts forward there as the fairy story, as Konrad said, will not address the issue of the public domain. And I won't even mention price, of course. There's a lot of analysis which shows that in public libraries, it's something like 3 to 4 is the price of the paper books, and in universities 10 times the price of a single seat license, 10 times the price of a paper book is not uncommon. So lots of issues there. But if we are talking about licensing again, I would just point people towards the ebook pledge for you to use in your negotiations with publishers, with an aim of creating fair and equitable and sustainable ebook licensing models. Before we have pan-European legislation that clearly allows ISDL, I would highlight. So again, I would like to thank Konrad for today's very clear, excellent presentation, and of course for the huge amount of work that not only Konrad but Maya and Ava and Katarzyna put in. It's a phenomenal piece of work. If you go on our website and look at today's the promotion for today's webinar, you can see the link at the bottom. I've also put it in the chat. So I don't know, Konrad, if people have questions. Are you happy to answer questions? Obviously, your area of expertise is international law and Polish law, so you might not be the best person to answer questions on Slovakian law or Slovenian law. But yes, if we do have questions either for Konrad or for Knowledge Rights 21, please send them in to us and we will do our best to help. But again, I would just underline it's a fantastic piece of work. The conclusion is we have a binding bit of legislation, and with the application of a fundamental rights lens to all this, there is no reason other than Slovakia why we can't take ISDL forward. So thank you very much indeed.
Thank you very much, and thank you for this great opportunity to be able to present the report. And once again, I thank you for KR21 for support of this study, because also from us perspective, it's very important to do it because we are very eager to secure the rights of fundamental rights of the user. I think this is a perspective which is very close to our heart in Future Law Lab and in Centrum Cyfrowe.
And if you're based at a library or a library association and would like sort of some more engagement on this, again, please contact us. So yeah. So perhaps we can now stop recording. We will make the slides available, and the webinar will be available on Knowledge Rights 21 YouTube channel.